Hello everyone, I am Mandeep Kaur Khurana, Assistant Professor of Law, going to discuss topic that is from Indian Penal Code, Fundamental Elements of Crime. This is the first topic of IPC. Yes students, when we talk about IPC, first thing I want to share with you that law is of two types, substantive as well as procedural law. First is substantive law. Substantive law like Indian Penal Code and procedural law of criminal law, that is CRPC, Criminal Procedure Code. So first we have to discuss substantive law, and the first topic, fundamental elements of crime, has been taken from substantive law, that is IPC. So fundamental elements of crime means when you are saying that that person is a criminal, he has committed so and so offense. Offense can be murder, rape, dacoity, etc. These all are criminal offenses. Okay, so first thing, what do you mean by crime? We have to clear the concept of crime first. Crime. According to Oxford English Dictionary, crime is an act punishable by law as forbidden by statute or injurious to the public welfare. So, according to Oxford English Dictionary, any act which is punishable means if a person is doing any act which is illegal. For example, a person is doing theft, and theft is punishable by law and also forbidden by our law. Hence, that person has committed crime of theft. And theft is third, which is public welfare, and obviously theft is against our public welfare. Hence, that person will be held liable for the offense of theft. Next definition of Stephens. According to the jurist Stephen, crime is said to be an act which is both forbidden by law and against the moral sentiments of the society. So, almost similar with the Oxford English Dictionary definition, Stephen is also saying that any act which is forbidden by law, जिसको हमारे कानून ने forbidden करा है, गलत ठहराया गया है, and against the moral sentiments of the society, which is against our morality, our morals, is known as crime. And next is, what do you mean by fundamental elements of crime? So if we want that I will sue against you, okay, then we have to prove that particular crime. For example, A kills B. If A kills B, then obviously now B is deceased and A has to give punishment. So how we can file a case against A, that is under CRPC, and how many punishment A will get, that is prescribed under IPC section 302, that is punishment for murder. Okay, so according to this example, I will share with you, according to my example, A kills B. Here both are human beings first thing, because we will discuss fundamental elements of crime. According to fundamental elements of crime, first person should be human being, second is mens rea, third is actus reus, and fourth is injury. Okay, according to this example, A kills B. A and B both are human beings. A kills B means, now here question arises where A intentionally kills B or whether A kills B because to protect his own self. This is the main question, and these will be held legal issues. Next is actus rea. Actus rea means action of our body. What we are doing here. What was the act? kill. Kill is act 1. A stabbed knife, suppose. Okay, then act stabbed knife. Injury. Here injury can be like grievous hurt. Here injury is person died. Person mar gaya. Okay, this was the consequences of A's act. Okay, so we will study these 4 points one by one in further slides. So briefly I will say how many elements of crime? 4. Okay, human being, mens rea, actus rea, and the last is injury. Next, there is a maxim, actus non facit reum nisi means sit rea. According to this maxim, the act itself does not make a man guilty unless his intentions were so. So, according to this maxim, the key point is intention. So, the key point is this intention. That the person, whether the person is having intention or not, that this concept I had discussed already in the previous slide. So according to this maxim, the act, एक बंदे का एक्ट अपने आप में उसको गलत नहीं ठहराता, उसको गिल्टी नहीं ठहराएगा जितनी देर तक उस पर्सन की इंटेंशन ना हो. सो इंटेंशन इज मस्ट. ओके, सो अकेला एक्टस रिया अपने आप में कुछ नहीं है, उसके लिए उसके साथ मेंस रिया होनी जरूरी है. और यू कैन से मेंस रिया प्लस एक्टस रिया इज इक्वल टू क्राइम. Mens rea is must, but there are certain exceptions also under IPC. From section 76 to 106, there are certain cases where person is held no guilty. Next is actus reus. Here, actus reus, what do you mean by actus rea? First, such result of human conduct, deed. A material result of human conduct means we are using the term again and again, that is human conduct. What human is doing, what his next step, whether he is doing a legal act or whether he is doing an illegal act. This is the main question. Okay, such result and whether his conduct is act plus omission, deed of commission. Act can be act or commission. Okay. What do you mean by omission? Omission means whenever there is breach of duty. Suppose police, suppose in a jail, a jailer is having duty to serve food 2 times to his prisoner. But what he was doing, he was skipping to provide meal to a prisoner. Okay, he is skipping intentionally. Why so? Why he was skipping? Because he was having grudges with that prisoner. Here, the jailer is doing omission. Okay, so omission means whenever a person is having duty to perform, but he is not obeying his duty, he is doing omission, that is against that person. Okay, and he will be held liable for that omission. Here I have quoted example. I suppose this example I had discussed in the previous slides. A stabbed B with knife. The result is the injury to B. It means injury to result of actus rea. मतलब कि जो भी उस बंदे ने उसको नाइफ के साथ वार किया है उसके ऊपर, उसके साथ क्या हुआ है, उस बंदे का दूसरे बंदे को क्या हुआ है, इंजरी हुई है, कोई भी नुकसान हुआ है. इंजरी स्लाइट हो सकती है, इंजरी सीरियस इन नेचर हो सकती है, ग्रीवियस हो सकती है, इंजरी कैन कोज इवन डेथ ऑल्सो. सो इट डिपेंड्स what is the nature of the injury. According to that nature, the person will be punished, but the person will be held liable and he will get punishment for that particular offense. So it will depend what he is doing. Next is mens rea. Mens rea means guilty mind. ओके, गिल्टी माइंड मीन्स बंदे की जो सोच है, जो उसकी इंटेंशन है, वो सही नहीं है, वो गुडविल में काम नहीं कर रहा, उसकी जो इंटेंशन है दैट इज ही इज हैविंग बैड इंटेंशन। ही व्हाट ही वांट्स, वो किसी बंदे को नुकसान पहुंचाना चाहता है इंटेंशनली। उसके बिहाइंड क्या हो सकता है? इंटेंशन उसकी हो सकती है जी मैंने इसके साथ बदला लेना है, उसके साथ उसकी कोई इलविल है, कोई ग्रजेस है। सो टू फुलफिल हिज ओन ऑब्जेक्ट, what he is doing, he is committing an offense with full intention. Okay, there is two case there are two cases, R versus Prince and R versus Tolson. These are very interesting cases and landmark also. So first we will discuss R versus Prince. In this case, what was happened? In this case, there was a person who loves a girl, and he presumed that girl's age is 18, and under this misconception he you can say he married with that girl without the consent of her guardians. Okay, but what was the real picture? The girl was of the age of 16, and under this misconception he was not aware. Okay, but he was charged for kidnapping. And in his defense, he said, "My lord, I was not aware that the girl's age was 16. I thought she has crossed the age of 18. So I married with her." But court held that no, you you will get punishment for this offense, because here I'm not talking about where you were having intention to commit that offense or not. According to law, this is an offense and you will be held liable. So ignorance of age or ignorance of law, this is not an offense in the eye of law. So he was held guilty for kidnapping. R versus Tolson. This is a case of bigamy. Under this case, facts. First, we will discuss facts of this case. In this case, there was a lady, Mrs. Tolson, who was married with Mr. Tolson in the year of 1880. After some times, her husband deserted her. She tried to consummate this marriage, but she failed. After some time, she get to know that her husband has died, and few years after, she remarries with the person without concealing any fact of her previous marriage. But after second marriage of Mrs. Tolson, her first husband arrives, and he charged, or we can say he filed a case against her wife under section bigamy and under section 57 offenses against the Person Act 1861. But in this case, the fact is Mrs. Tolson Mrs. Tolson were having this knowledge that he had died. That's why she performed second marriage. She was not having any intention, even she don't want to, like you can say, she don't want to give him any type of crime. She don't want to commit any type of crime. Actually, she was not having any mens rea. In this case, court held कि जो ये लड़की है Mrs. Tolson, she was not having intention to commit bigamy, but circumstances are like that कि उस बंदी ने without any intention she has performed second marriage. So in this case, there was absence of mens rea, and what she has done, she has done with good, she has done in good faith. Okay, so her second marriage was held valid and उसको कोई punishment नहीं हुई, उसको छोड़ दी. Next is, there are certain exceptions to the doctrine of mens rea. Only in the cases where applicability of mens rea is excluded by the statute, then only it can be exempted. Few exceptional circumstances like public nuisance, or you can say cases which are not criminal in nature but are prohibited in the interest of public at large. For example, environment pollution, consumer protection laws. So these are some exceptions of the doctrine mens rea. Next, last element of fundamental elements of crime is injury. In the starting, I have told that injury can be slight, injury can be more heinous, serious, like grievous hurt, death, rape, etc. According to section 44 IPC, injury is any harm whatever illegally caused to any person, body, माइंड, रेपुटेशन, प्रॉपर्टी. सो इंजरी जरूरी नहीं है कि उस बंदे की बॉडी को मिलेगी जी सिर्फ वही इंजरी है, नहीं. अगर वो बंदा उसके खिलाफ उसकी बॉडी को एज वेल एज उसकी रेपुटेशन को, उसकी प्रॉपर्टी को, उसके माइंड को हार्म पहुंचा रहा है तो वो भी कंसिडर किया जाएगा इन द डेफिनेशन ऑफ इंजरी. सो ही विल बी हेल्ड लायबल. ओके, सो दीज आर 4 elements of a crime. First was human being, second is mens rea, third is actus rea, and last is injury. If these 4 elements are available or present in any act, so that act can be a crime. Okay, so main highlighted portion is mens rea, whether that person has committed that offense with full intention or without intention. If he has committed an act without guilty mind, but suddenly from the circumstances or like his bad, bad luck, she has or he had done that act. According to the circumstances, we can presume whether he committed that offense or not committed that offense. Thank you.